All right, everybody. I hope everyone is doing well today. How did your discussion group go today? Did you guys participate in this discussion group today? I saw that Jeremy had uploaded a question over there. Didn't do much. Oh, okay. Yeah, so that's fine. I saw that it was a pretty good question. If you did not hold the discussion on that question, maybe we can do that sometime later on, or maybe you can work on that question as your assignment, and I'll be happy to give you feedback on that. Oh, okay. All right. So not ready to discuss the question. So you guys agreed to do that next week. Okay, that sounds good. Yeah, because the topics that were covered in that question are going to be discussed today in our today's lecture. So you'll be in a better position to discuss that next week. All right. So welcome to lecture 8 of contract law, and we are going to continue with our discussion on consideration. And today our main topic is going to be promissory estoppel, as you all know. But before that, before we move on, I just wanted to make one small point with you guys, which is that consideration must move from the promisee. We didn't discuss this much last time, so I thought that I must bring it up before we move on to consideration. So let's look into it and see what it actually means. So this simply means that the benefit must be conferred or the detriment must be incurred by the promisee if he wants to sue on the promise, and not by someone else. So promisee is your key person here. So the promisee needs benefit must be conferred by the promisee or detriment must be incurred by the promisee. Let's think about the example that I gave you in my last lecture. That remember we discussed two angles of consideration, that I drive you to Oxford, which is a benefit and a detriment, right? It's a detriment to me and it's a benefit to you, and you pay me 50 pounds, which is again a benefit and a detriment. So you pay me 50 pounds, so this is a detriment to you and it's a benefit to me. So let's say if there is a situation, I am suing you for breaking your promise. So what was your promise to me? Your promise was that you were going to pay me 50 pounds, but you did not pay me 50 pounds, so I am now suing you because you broke your promise. So in this situation, in this particular situation, you are the promisor and I am the promisee, right? So the benefit must be conferred by me, or the detriment must be incurred by me. Let's reverse the situation, and let's say that you are suing me because I broke my promise. You paid me 50 pounds, but I did not drive you to Oxford. So I broke my promise, and you are suing me because I broke my promise. So I am the promisor here, and you are the promisee. So in that situation, the benefit must be conferred by you, or detriment must be incurred by you for it to be considered as a consideration. And this rule was derived from the case Tweddle versus Atkinson, where the fathers of a soon-to-be married couple promised to pay soon-to-be husband a sum of money upon the marriage. So the consideration for each promise was the promise of the other. That is, the bargain was, I'll give him some money if you do too. So both of the fathers, the father of the bride and the father of the groom, were to pay money. So after the wedding, the bride's father neglected to pay the money. But the court held that husband could not sue for the promised money. Why? Because the consideration was provided by his own father by promising to do the same thing, and was not provided by the son who was trying to enforce the promise. So a wiser approach would have been from the son's side that he could have asked his father to sue And in that case, it would have make sense because the father was the one who was providing consideration, and his father was the one who was a promisee, and he could, of course, have sued. So just wanted to make this point clear. Okay, so now let's talk about some special kind of promises, which are non-bargain promises that are not bargained for. So non-bargain promises basically are promises where the promiser does not request anything in return, right? He promises for free, basically, so or for nothing. Let me give you an example. Let's say that I think my niece is a splendid person, and I promise to pay her £100 tomorrow, just because I think she's a wonderful person. She does not have to do anything in return, and I have not asked her to do anything. Now, should she be able to enforce my promise against me? She has not done anything in return. Now, whether or not you think such a promise should be enforceable, the case for enforcement becomes a lot more stronger if the promisee relies on the promise. So, especially if the promisee relies on the promise to his or her detriment. Now, in this same example that I just gave you, it would be this would be the case if my niece, let's say, took out a friend for an expensive meal in reliance on my promise to pay her. She knows that I'm going to pay her £100 tomorrow, and she said that she took a friend out for a dinner, an expensive dinner. Now, it could be argued that she should be entitled to sue me for at least the money she has spent on the meal. So, in the non-bargain promises, the case becomes stronger if the promisee relies to his or her detriment. Now, the traditional approach, basically, to non-bargain promises is derived from Cont versus Cont. Now, in Cont versus Cont, you have to remember that the promise was not enforced precisely because the husband had not made a bargain that in return for his promise to pay his ex-wife, she would refrain from applying to the courts for maintenance. So the promise was not enforced in that case. And it was said that she did that on her own will, so this detriment could not amount to consideration for her husband's promise. So that is the traditional approach that is pertaining to non-bargain promises. Now, there are two opinions about this situation. One opinion is that to accept the traditional narrow view of consideration, right, that non-bargain promises cannot be enforced because there is no consideration, and then supplemented with a non-contractual regime where non-bargain contracts are enforced through Estoppel. So accept the view of the narrow view of the consideration and then supplement it with Estoppel. So use Estoppel to enforce non-bargain contracts. And then the second opinion is to widen the definition of consideration beyond bargained for promises. So some writers suggest that non-bargain promises should be included in that regime. So this is just to give you an idea as to the history of the debate surrounding the non-bargain promises, and you're welcome to write about two opinions in your exam, especially if it's an essay question. Now, we just discussed that one of the views is that to accept the traditional view, narrow view of consideration and supplement it with Estoppel. So now what is Estoppel? In this course, you are mainly concerned with two types of Estoppels. Focus of this course is on promissory Estoppel, and we don't talk much about Estoppel by representation, but you do need to know the history of Estoppel by representation. So Estoppel by representation No, as its name suggests, is estoppel. This particular estoppel is not concerned with promises, but instead can arise when one party makes a false representation. So a false representation of a fact upon which the other party acts. Okay, so that is your estoppel by representation, and this is also called your common law estoppel. Now, where the justice demands, and remember that this particular flexibility where the justice demands is the key feature of all estoppels. So where the justice demands, the first party is stopped or barred from denying the truth of his representation. The main case for this kind of estoppel is Jordan versus Money, and it was decided in 1854. Now, Mrs. Jordan had said time and time again that she would not enforce a bond. A bond is a type of a debt against Mr. Money. So Mr. Money then married, relying on his belief that the debt would not be enforced and that his financial position was secure. Now, in order to make his position crystal clear, Mr. Money sought a declaration from the court that he had been validly released from the bond, and he also sought an injunction to prevent it being enforced. Mr. Money could not argue that he had been released from the debt under a contract, because at that time the statute of frauds required such contracts to be in writing and signed. So what he did was therefore he had to argue his case in estoppel. That was the only way for him. Now the House of Lords decided that Mrs. Jordan had promised not to enforce the bond in future. Right? Now what is the key word here? That she had promised. Promise is the key word here. Promised not to enforce the bond in the future, but she had not made a statement of fact that the bond had been discharged. So you see the difference? She had promised, but she has not made a statement of fact that she had discharged the bond. So accordingly, she was not stopped from denying that the bond was discharged, because estoppel only applied to statements of facts and not promises. So this case clarifies that estoppel by representation can only be applied to a statement of fact and not a promise. And this is your common law estoppel. Promissory estoppel, on the other hand, is an equitable doctrine. Right? Remember the difference between equity and common law and how they amalgamate and now are enforced in the same courts. So this is an equitable doctrine of promissory estoppel, and it allows a promise to waive legal rights to be enforced even where there is no consideration for the promise. So even where you do not find a consideration, promissory estoppel can play a role there and makes it a binding contract. So in the last slide, in the case of Jordan versus Money, again, just to review, courts held that estoppel cannot be applied to promises. But later on in 1877, in Hughes versus Metropolitan Railway Company, the House of Lords gave effect to conduct which amounted to a promise. So they gave effect to a conduct which amounted to a promise as to future conduct. Now the landowner Hughes served notice on the railway company to perform repairs on the property it leased from him within 6 months on pain of forfeiture of the lease. The railway company said that it would carry out the repairs. But before it did this, it wished to hear from Hughes on its proposal for Hughes to buy the railway company's leasehold interest in the property. Now the parties entered into negotiations, but they did not arrive at an agreement. And Hughes then sought to eject the railway company from the property 6 months after it had served the notice of repair. The railway company performed the repairs 2 months later. The House of Lords held, in this case, that Hughes' conduct had led the railway company to believe that Hughes would suspend his strict rights under the lease during the period of negotiation, and it would be inequitable. It would be inequitable to allow Hughes to later enforce those strict rights. So in essence, Hughes was held to have promised that he would not treat the 2 months of negotiations as counting towards the 6 months in which the railway company had to repair the property, with the consequences that the railway company had completed the repairs in time. So the decision in Hughes was largely basically ignored until 1947. So although this kind of the discussion about how the inequity or it would be inequitable for a person to go back on his promise started in 1877, but it was not again discussed until 1947, until Lord Denning brought it into light in the case of Central London Property Trust Limited versus High Trees. Now here in this case, Lord Denning said that, these are his words, that the law has not been standing still since Jordan versus Money. Before identifying a broad principle now known as promissory estoppel, a promise intended to be binding was intended to be acted upon, and in fact acted upon is binding so far as its terms properly apply. So this is a very important phrase that he used, and it is still used, that a promise intended to be binding was intended to be acted upon, and in fact acted upon is binding so far as its terms properly apply. So let's look at the facts of the case. In the case itself, if you look at the facts, the landlord had leased out some flats in London for £2,500 per year, but the Second World War intervened, and unsurprisingly, it was difficult for the tenant to sublet the flats as he had originally intended. The landlord said that he would accept £1,250 per year in discharge of the tenant's obligation to pay £2,500 per year. Now, Lord Denning thought that the promise to accept less was enforceable only so long as the wartime conditions existed. Okay, so as soon as the war ended and flats could be sublet again, the landlord could claim the full contractual rate of £2,500 without acting inconsistently with his promise. And this was sufficient to dispose of the case because the landlord only claimed the full rent from the end of the war. So, however, Lord Denning's principle would have stopped the landlord from claiming the extra rent, the difference between £2,500 and £1,250, if he had claimed it during the war years, because the promise to accept less was intended to be binding, intended to be acted upon, and was acted upon. So while it was accepted that the relied on promise did not create a cause of action in damages, the landlord could have acted inconsistently with his promise and claimed the original contract price of £2,500 per year for the war years. So the landlord's legal right to the full rent during the war had therefore been extinguished. So just keep this thing in mind that according to this case, the landlord's legal right to the full rent during the war had therefore been extinguished. So this is an important case where promissory estoppel was again discussed. Okay, just to make it clear, let's discuss an example here. So I lend you £100. Okay, you are under a contractual obligation to pay me £100. Later on, you explained how it is tough, being a student and I agree in order to help you to continue your studies that I will accept only 75 pounds in discharge of the debt because it is so difficult for you. You're a student. You pay me 75 pounds and go and you buy a new textbook that you could not afford before. Later on, I rethink my generosity and I sue you for that extra 25 pounds. Now, do I have a case? Okay. So Bash and okay. Can Andre, you think there can be or there might be or there might not be a case? Okay. Can somebody give me a reason for that? For what they're saying? Andre is saying maybe, and Ruhin is saying no. Sandeep is also, he thinks it's not. So why do you think so? Whatever your answer is, why do you think that I have a case, or why do you think I do not have a case? Okay. Yeah, Bash is saying that I acted to my detriment based on your promise. Good. And Sandeep, because the new promise was made, I was agreed to by both the, it was agreed to by both the parties. Okay, so Sandeep, you are arguing that it was a binding variation of the contract. But in order to say that it was a binding variation of the contract, what was the consideration from my side if I accepted less money? If I accepted 75 pounds, was there any, I did not provided any consideration to that. So in order for it to be a binding variation, don't you think there has to be a consideration for the second type of contract that you are arguing? Okay. Okay, so Sandeep, yeah, you're saying that there should be a new consideration. So, so it is this new concept of promissory estoppel. So it is excellent that you argue that this was a binding variation of a contract. It's good to argue that in a question. Always argue that first in your exam question, and then if you do not see any consideration, then bring in your promissory estoppel. Then bring in your arguments about promissory estoppel and see if it is if I can recover 25 pounds or not, or if I have a case or not. Okay, so all of you are thinking in the right direction, which is good. So remember in Folks versus Beer and another case, re-select move, both of these cases make it clear that there is no consideration for my promise to discharge the debt, right? So there is no contract for the partial discharge of the debt. The contractual obligation stands, and you still owe me 25 pounds. However, my promise to discharge the debt on receipt of 75 pounds was, like one of you said, I think dash said that it was intended to be binding and intended to be acted on by you, and you acted on it by paying me £75 and also by buying a textbook. So following Lord Denning in High Trees, I should not be allowed to enforce my strict legal rights under the original loan agreement, if to do so would inequitably allow me to act inconsistently with my promise. Whether you can resist my claim to the £25 indefinitely is another question. It may be that the estoppel only suspends rather than extinguishes your obligation to pay, and it might be that it can be revived after you have been given reasonable notice. After all, you can to some extent resume your original position by selling the book, or possibly even getting a refund. Or I could wait until you graduate and you become a successful lawyer and you become very rich to sue you. But of course, all have to be within the 6-year limitation period, of course. So let's see what you guys are saying. Okay. So do you understand this concept? This little example? If everybody's okay, then we'll move on. Okay. All right, so let's see. We'll look at the same example, but with we're going to change the facts a little bit here. Imagine now that there was no prior loan agreement between you and me, and you are therefore under no pre-existing obligation to me. And then you just come to me and you explain how it's tough being a student, and I promise to pay you £25 to help you along. You again buy that long sought after textbook that you always wanted. So we change the facts a little bit. Now there is no existing legal relationship between you and me. What do you think? Does this change the situation? So there is obviously no consideration. If you look at the facts, no consideration for my promise, because you have given me nothing in return. So there is no contractual obligation for me to pay you. My promise was intended to be binding and intended to be acted upon, and you did act upon it, but the courts will still not enforce my promise. This is because the courts can only prevent me from acting inconsistently with a promise to modify or discharge a pre-existing contractual obligation. So they cannot make me honor all of my promises by positively enforcing them as though they were contracts. The key point is not that all relied upon promises are enforceable, but that I cannot blow hot and cold, as in the first version of the facts in the previous slide, telling you 1 minute that the debt is discharged and the next minute that you owe me £100 or £25. In this version of the facts, in this alternative facts, I do not have to pay you £25 because we did not have any existing legal relationship. So this brings in the discussion of the first limitation on promissory estoppel, that there has to be an existing legal relationship. Okay. Now, interestingly, Lord Denning disagrees. There is a case, Evenden versus Guildford City, where Lord Denning said that promissory estoppel could apply in a situation where there appeared to be no existing legal relationship between the parties. But remember that the majority of the decisions support this rule, that an existing legal relationship is needed for a promissory estoppel to play a role. But if you come across, when you discuss this in your exam, feel free to mention that Lord Denning disagrees in the case of Evenden versus Guildford. Right? Okay. So there is another case, and we're going to talk about the second limitation on promissory estoppel, need for reliance. In the Post-Chaser case in 1982, Robert Goff thought that detrimental reliance was not necessary for promissory estoppel. Okay, and then you'll see that other cases in Ajayi versus Briscoe, Lord Hudson remarked that promissory estoppel may be induced if the other party altered his position on the basis of the promise. Okay, so and in this case also established a limitation to estoppel in situation where it is impossible for the promisee to resume his original position. Again, interestingly, if you look at the case of W.J. Allen, Lord Denning said that I know that it has been suggested in some quarters that there must be detriment, but I can find no support for it in the authorities cited by the judge. And then he says, if you study the cases in which the doctrine has been applied, you will see that all that is required is that one should have acted on the belief induced by the other party. Again, Lord Denning is sort of disagreeing with the rule. So if you look at all of these cases, if you read these cases, it is unclear whether the promisee must rely on the promise to his detriment. We just discussed the case of high trees. So in high trees, in the previous slide, it is difficult to see how the tenant acted to his detriment by simply paying less money. So the tenant in that case was paying less money per year. So how is that a detriment to the tenant? And then in the Post-Chaser, as we said that Robert Goff said that the detriment reliance was not necessary for promissory estoppel. So looking at the cases, it would be easier to show that it would be inequitable to allow the promisor to deviate from his promise when there has been a detrimental reliance. So it would be easier to show that. For example, detrimental reliance is helpful in proving inequity, right? So if you acted to your detriment, it would be easier to prove inequity. On the fact, the promisee's position had not been prejudiced by his reliance on the promise in the Post-Chaser, and Robert Goff held that it was not inequitable to allow the promisor to rely upon his strict legal rights under a pre-existing obligation. So this area of law there is a lot of debate here, and again, as I always say, that feel free to mention all of the opinions and this debate in your exam question when the time comes to discuss this limitation on promissory estoppel. So it is basically not very clear whether the reliance should be detrimental or not, but it is an easier case if it is detrimental reliance. And why is it easier to prove? Why is it easier if the reliance is detrimental? Let's see. Who would like to answer this question? So I just mentioned that this case law is a little, this area of law is unclear, not very clear. But it is easier to apply promissory estoppel if the reliance of the promisee was to his or her detriment. I'm looking for that keyword. More justified. Okay. Bash is saying, I don't think it's easier to prove, it's just more justified. And justified, or another word for the same thing, we've been using that all along. Sandeep, okay, Sandeep is saying it is probably a greater degree of support to the promisee because he acted to his detriment. Yeah. And it would be equitable. Yes, equitable. That's the word I'm looking for. Yes, Sharon and Bash, excellent. So this is more equitable, right? And remember, promissory estoppel is an equitable doctrine. That's the essence of this doctrine. So it would be more equitable, exactly, right? In other words, it would be inequitable for the promisor to go back on his word if the promisee has relied to his detriment. All right. All right. So third limitation on promissory estoppel is that it is a shield, not a sword. And this the case that came up with this doctrine was this limitation was Cont versus Cont. Okay, and let's look at the facts of the case quickly. So during the divorce proceedings, defendant promised to pay the plaintiff, who was his ex-wife, £100 per year maintenance. Okay, so defendant failed to pay. Plaintiff was in a better financial situation and did not pursue court proceeding for the money. However, several years after the divorce was finalized, the plaintiff brought an action for the arrears of £675. The issue was the promise enforceable? Now, the counsel in this case, in Cont versus Cont, was credited by Brackett with inventing the phrase, and the phrase was, promissory estoppel can be used as a shield but not as a sword. While many students remember this, it's a catchy little metaphor and everybody remembers that, it does not in itself explain the scope of promissory estoppel. You need to ensure that you understand that promissory estoppel is a shield because, why is it a shield? Because it can block actions on pre-existing obligations where there has been a fresh promise unsupported by consideration. That is a non-bargain promise. So, to modify or discharge the pre-existing obligation. Okay, so in this way, the landowner in Hughes, if you remember the facts of Hughes, was not allowed to rely on his strict legal rights under the lease because these had been modified when he indicated that the time would stop running against the railway company during the negotiations during the 2 months. And similarly, the tenant in High Trees sought to use estoppel defensively against the claim by the landlord based on his strict legal rights. And the difference, if you remember the facts of the case, the difference being that the landlord's claim for the full rent after the war succeeded in this case because the estoppel only extinguished his strict rights for the duration of the war. Now, so promissory estoppel cannot be used aggressively as a sword. So it was decided in that case as well that promissory estoppel could not be used aggressively as a sword in the sense that it cannot be used to enforce a standalone non-bargain promise to pay £100 as in this case in Cont versus Cont. The promisee therefore must wait to be sued actually. The promisee must wait to be sued on a pre-existing obligation and then use promissory estoppel as a defense. In other words, as a shield. So under English law, promissory estoppel mitigates the harshness of the rule that a promise to modify or discharge a contract must be supported by consideration, but it goes no further than that. You just have to remember that it does not go further than this at this moment. Um, Maybe in future there might be some changes coming up, but right now it does not go further than that. Joel, I think you're having some problem with the slide. Is everyone else able to see the slides? Okay. All right. All right. So our fourth limitation. It must be inequitable or unfair or unjust for the promisor to insist upon his strict legal rights after he has promised that he would not. Simply, it is as simple as that. Now, this requirement was introduced by Lord Denning in DNC Builder Limited. You can see the facts of the case on the slide. So this limitation was introduced by Lord Denning on this case, DNC Builders. Now, in this case, a firm of builders accepted a lesser sum in discharge of a larger sum. Lord Denning thought that despite their promise to accept less, it was not inequitable for the builders to insist on full payment of the existing debt, because Rees had exploited the builders' desperate need to be paid some money in order to avoid insolvency. This case was decided before the doctrine of economic duress was introduced, but it was obvious that the promissory estoppel, as it is an equitable doctrine, would not tolerate any undue pressure being placed on the promisor. So, in simpler words, it must be inequitable for the promisor to insist upon his strict legal rights after he has promised that he would not do so. So, Lord Denning's obiter comments are quite interesting here, and let's read that together. So remember that he said that in obiter. I hope everybody knows what is obiter dictum by now. Is everybody aware? Okay. All right. Can anybody just give me a small explanation of what is an obiter dictum in a decision? Just in case, you know, any student doesn't know. So just to clarify, what is an obiter dictum? Ratio, testinendi, and obiter dictum. Saliha. Right. So Saliha is saying what a judge mentions as by the way comments. Excellent. Very good. And the obiter is not binding. Very good. Okay. So very good. All right, Andre. Things said in passing. Exactly. That's obiter dictum. So obiter dictum is not binding, as we all know. And Lord Denning said that in obiter, we can say that when a creditor and debtor enter a course of negotiations which leads the debtor to suppose that on payment of a lesser sum, the creditor will not enforce payment of the balance, and on the faith thereof, the debtor pays the lesser sum, and the creditor accepts it in satisfaction, then the creditor will not be allowed to enforce payment of the balance when it would be inequitable to do so. So these were his obiter comments in DNC Builder. Okay. All right. So a debate surrounds the issue of whether promissory estoppel extinguishes the rights or whether it only suspends the right for a limited duration, limited time period. And the case that discusses that is Tool Metal Manufacturing Company Limited versus Tungsten. This case deals with the question of the extent to which or the duration for which it will prevent someone going back on a pre-existing promise. Okay, so extent to which or a duration of which it will prevent someone going back on a pre-existing promise. Now we know that the promisor is stopped from asserting his strict contractual rights when he has promised not to do so. But is the effect of this estoppel temporary or permanent? Now this question generally arises when there is a contract with recurrent or continuing obligations. There are some cases that suggest that promissory estoppel extinguishes the promisor's right forever, but others suggest that the original contract can be resurrected by giving notice. In this latter case, the promissory estoppel is suspensory only. So in Tool Metal Manufacturing Company Limited versus Tungsten, the owner of a patent promised not to enforce the strict rights he had under a contract. He did this because the Second World War had interrupted the contract, and that also had happened in high trees. So the same way, the Second World War had interrupted the contract, and the Court of Appeal held that the promise could be revoked by giving reasonable notice. In other words, the promissory estoppel only operated to suspend the strict rights under the contract and not to extinguish them entirely. So that was the decision in Tool Metal Manufacturing. It only suspended the rights and did not extinguish the rights. In high trees, in the case we discussed earlier, Denning appeared to say that the right to collect full rent for the war years had been extinguished, but this did not apply to the years after the war because the promise was only meant to apply to the war years. Now this might appear to be a different route on the same solution. These are two different routes, but you get the same solution. If it makes a little difference whether the estoppel is said to be suspensory in effect or whether the promise is held to relate to a specific or limited time. But in high trees, the obligation to pay the full rent during the war years was not suspended. Those particular obligations were extinguished forever. Even if the obligations to pay the full rent in the years after the war were unaffected, thus they could be revived. Now, in reality, the exact effect of promissory estoppel in a particular case, it depends on the precise nature of the promise made and to what extent it would be inequitable to allow the promisor to go back on it. But there seems little doubt that in an appropriate case, particular legal rights can in effect be extinguished. So basically, again, this area of law, there is a lot of debate surrounding this area of law, and you're welcome to talk about both of the routes, the route that Lord Denning took in high trees and the route taken in tool metal manufacturing. And it basically depends on the exact and precise nature of the case and how inequitable would it be. So it depends on that. Okay. So, but as a general rule, actually we cannot say it's a general rule, but majority of the cases support that it has to be suspensory. The effect has to be suspensory. However, do not ignore the comments of Lord Denning in high trees, and do not forget the second route, and discuss both in your exam. Okay. All right. So another limitation on promissory estoppel came from the case Evans versus Amicus. It is quite a recent case. It was decided in 2003 with very interesting facts, and the limitation is that what if the promise is prohibited by legislation? What happens then? So promissory estoppel does not apply if the promise is prohibited by legislation. Okay. So in this case, there were two Evans versus Amicus Healthcare. There were two women who had been undergoing IVF treatment with their respective partners and wanted the embryos transferred after the breakdown of their relationship. Okay. So each couple had signed a consent form in accordance with Schedule 3 to the Human Fertilization and Embryology Act 1990, and this is also called the 1990 Act. So they had signed in accordance with that legislation. And this schedule stated that the embryos were to be used in providing treatment services to the person giving consent and another specified person together. On the breakdown of the relationship, the male partners then decided they no longer wish to proceed with the treatment, and they expressed a desire to have the embryos destroyed. In accordance with Schedule 3 that I just mentioned, either party to IVF treatment was free to vary or revoke consent prior to the use of the embryos. Okay, so these were the facts of the case. So the male partners were allowed by the legislation to take back their consent. So in this context, it was found that the man had not given such assurances to the woman as to create a promissory estoppel because the relevant legislation was Schedule 3 Para 4.2 of Human Fertilization and Embryology Act of 1990, allowed him to withdraw his consent to the storage of embryos at any time. So the estoppel did not apply in this case. Okay, so let's discuss another confusing area of promissory estoppel. Okay, so if you look at the case law, the promissory estoppel has been invoked in situations concerning usually continuing obligation, right, such as rent or maintenance, and it has not been applied in situation where there was a one-off payment, such as a pre-existing debt. However, remember the obiter remarks made by Lord Denning in BNC Builder? It suggested that he would consider it possible to apply promissory estoppel to a debt if the debtor had acted equitably. This approach presents possible conflicts with earlier decisions regarding part payment of debts, which were decided in Folks versus Beer. So in Folks versus Beer, the issue was the agreement made for part payment of the debt, excluding the interest, enforceable? So the main issue in Folks versus Beer was that agreement enforceable that was made for part payment of debt. And in the House of Lords, it was held. House of Lords actually accepted that the plaintiff had agreed not to sue on the judgment at all, even for interest, but that this was not enforceable, as the defendant did not provide good consideration for this promise. The decision in Folks versus Beer, which was decided in 1884, upheld the principle outlined in the Pinnell's case, which was decided in 1602. And that principle in Pinnell's case was also said in Obiter. And it was, if a fixed sum is owed, then payment of a lesser sum can never be satisfaction for the full amount, for the full amount owed if no consideration has been provided. So this rule was upheld in Fox versus Beer. However, you should note that the remarks made in DNC Builder versus Rees were, again, as I have mentioned earlier, made obiter, and that Lord Denning did not argue that a creditor should never be allowed to enforce payment of the balance of a debt, but merely he should be limited if it would be inequitable. Now, clearly in that case, the creditor was entitled to claim the balance as it was equitable on the facts. And in the case that we discussed previous to that, High Trees, Lord Denning took the principle of promissory estoppel and applied it to the case at hand, and he said that in Hughes, he referred to Hughes' case while deciding High Trees' case, and said that there had been a promise made that was intended to be binding, intended to be acted upon, and in fact acted upon. And such a promise should be binding insofar as its term properly applied. Now, interestingly, this approach extended the notion of equitable waiver into the area of part payment of debt. So you need to remember that in High Trees, Lord Denning referred back to Hughes and applied this equitable waiver, the doctrine of equitable waiver, into the area of part payment of debt. And then Lord Denning also, when deciding that case, gave a justification of this decision. And according to Lord Denning, he said that when he was questioned that when this conflict of his decision with Fox versus Beer was questioned, he said that Fox versus Beer was decided on common law principles, ignoring the role of equity. Now, it is interesting to see that Fox versus Beer was decided after equity and common law had amalgamated. So, and many other people and commentators criticized Lord Denning's comments that Fox versus Beer ignored the principles of equity. Now, but we here, you guys as students encounter this difficulty as to how to reconcile High Trees with Fox versus Beer. Now, the decision in High Trees could be reconciled with Fox versus Beer, in that promissory estoppel will simply suspend the debtor's obligation to pay rather than extinguish the creditor's right to the balance of the debt. But if in reliance on the creditor's promise to accept part payments, the debtor had spent the money he would have used to pay the balance, it may be inequitable for the creditor to go back on his promise to accept the part payment. So this is another area of law which again has a lot of discussion surrounding it, and it is quite likely to see this kind of a question in an essay form in your exam, an essay on part payment of debt. So, and this can easily be in one of your problem questions as well. But this also makes a good essay question. Okay. Here is an example of an essay question which discusses the same area that we just discussed in the previous slide. Okay. So the question is, doctrine of promissory estoppel cannot be regarded as casting doubt on the decision in Fox versus Beer. If that case were to occur today, the House of Lords would decide it in exactly the same way. Okay, so do you think you are a little bit prepared to discuss this essay question? Okay, let's start by stating what cases are you going to do. Let's suppose you encounter this question in your exam. What case law comes to your mind? What are the cases that you're going to discuss? in this essay. Sandeep is saying high trees. Okay, good, very good. Like we just mentioned in the previous slide. Yeah, you're right, Sandeep. High trees is one of the cases we are going to discuss, as Lord Denning talked about, applied the promissory estoppel notion to part payment of debt. Okay, what else? And what case did he refer to while talking while deciding high trees? What case did he refer to? Anyone? Hughes. Yes, Hughes. Absolutely. So he referred back to Hughes and applied that to high trees. Okay. And one of the main cases that you're going to discuss that is given here in your question, Folks versus Beer, right? That is going to be your main case that you're going to discuss, Folks versus Beer. And what principle? Where did that principle come from that was applied to Folks versus Beer? What was the case law for that? Anyone? Bash, how about you? Femi? Tinel? Yes, yes, Andre, exactly. Tinel case. That is from where the rule was derived. Very good. And that was applied to Folks versus Beer. But later on, high trees was decided, and Lord Denning referred to Hughes while deciding that. So all of these cases need to be discussed here. So I'm going to end our lecture today on this note. And so this week's assignment for you is going to be to read all the cases that we just discussed, right? High trees, Hughes, Tinel, and Folks versus Beer, and try to answer this question here. Is everyone okay with this assignment? Okay, good, great. All right, everybody, thank you very much, and I will see you next week. Feel free to take a print screen or print shot and screenshot and paste it onto a Word document so that you have this question saved somewhere, and then write your answers to it after you have read all the cases that we just mentioned, and then later on email it to me. Email it to me no later than Wednesday, so that I have time to look at it before our next session. Okay. All right. Thank you very much. I'm going to mute myself here. You guys can have a discussion on this question if you want. Okay, Femi, you want to submit it by Thursday? That's okay. That's fine. I'll try my best to give you feedback before Saturday, but if not possible, then I'll probably give you a feedback next Sunday or Monday. Okay. All right. So feel free to have a discussion on this question right here on this forum, and I'm going to mute myself here.